Right since the Delhi High Court ordered suspension of the life sentence to former BJP MLA from Unnao, Kuldeep Singh Sengar, there has been an uproar both over social media as well as on the street as victim herself took to the streets to protest against the Delhi High Court order. But what was there in the order and what was the basis on which Delhi High Court suspended the sentence? To discuss and dissect that judgment, we have with us Advocate Mehmood Pracha, who himself represented the victim. So, first of all, as an advocate who represented the victim of such ghastly crime, how do you see this judgment overall?
Not just one ghastly crime, but a series of ghastly crimes, beginning with the rape of the girl child who was just like a daughter because of the family relations they had. Thereafter, to suppress the family from not recording any police complaint, she was kidnapped and gang raped. Thereafter, her father was murdered by the police to suppress the family. Thereafter, even after Supreme Court's intervention, transfer of cases, the girl child and her lawyer, two of her relatives, were attacked by a truck while they were moving in a car going to a court, in which the lawyer died, two of her relatives died, and she almost got killed. Right. Thereafter, further threatenings and FIRs. And as late as 2 weeks ago, the husband of the victim was assaulted, and he was he can't even, he's got serious injuries. Now, the reason for giving this suspension of sentence that needs to be criticized, that is the criticism of the judgment, is that the court showed its extraordinary magnanimity, kindness, and mercy. So the question is, does this person deserves this extraordinary mercy, kindness, magnanimity of the court? What had he done till date other than committing one crime, one heinous and horrendous crime after the other? What did he do to earn this kindness from the court? That is the core issue in this.
Okay. So, in terms of the understanding of the entire judgment and the relief that Sengar has got, a lot of emphasis has been put on if he was a public servant, and a lot of relief has come from the same basis. How do you look at this entire argument, and what's your take on this basis?
Now, firstly, you see, even in UAPA cases, where the conditions are most stringent for bail, when the accused is presumed to be innocent. In UAPA cases, the difficult most condition is that the court will have to give a finding that prima facie, apparently the accused seems to be innocent, only then bail can be granted.
Yes.
The thumb rule there is bail, not jail. The moment you get convicted after a trial, the situation reverses. It is jail, not bail.
Right.
Now, if that is the situation, if bails are being denied in UAPA cases, that's the intent of the legislation. In this case, there is nothing prima facie. He is a confirmed convict.
Right.
So how can he be granted this liberty of coming out of jail on the ground that there is going to be a delay in deciding the appeal? That is the end. And now coming to your pointed question about public servant, these are all hypertechnicalities. These hypertechnicalities cannot be gone into during a case of suspension of sentence. It is prohibited. Factual aspects cannot be gone into during the argument of a suspension of sentence case. All those have been dealt with. We were vehemently requesting the court to kindly hear the appeal first, because it is going to take less time and there should be no grievance to either side. If he is held guilty once again, he remains in jail.
Yeah.
He's declared innocent, he comes out. After I became a lawyer in this case, this proposition was not gullible to the accused side, to the convict side, for understandable reasons. So they flatly refused. They said, no, we don't want the appeal to be heard. We want that suspension of sentence should be heard first. And it took more time, ironically, than the main appeal would have taken. That's another criticism of this judgment.
Are you suggesting that they banged on this hyper technicality, say that he was not a public servant as per the definition given in the IPC and also in the section of the POCSO Act? So do you think that it was a smart ploy on the part of Sengar's lawyer? Or the court could not read that?
I mean, not Sengar's lawyers, I would say. It was a smart play by the CBI.
Okay.
CBI, central government, UP government, and a cartel of international gangsters who are friends with Kuldeep Singh Sengar Saab. They had conspired in such a manner that CBI was hand in glove with him. And this is not my statement, I'm just paraphrasing. There is a finding by the trial court which goes to say that CBI's IO, investigating officer, was helping Mr. Sengar. It is a finding which has not been set aside as of now. Although CBI has moved an application for expunging these remarks. He is the one, CBI is the one who is helping the accused getting acquitted. They are slanting the investigation in such a manner that he gets accused. He gets acquitted.
Okay. So
it is mainly the fault of central government, state government, and the CBI and the cartel of criminals. Which so that I would not shy away from saying this. The duty, the prime duty, the very existence of our court, all courts, it is settled law, is to find out the truth and dig deeper to find out the truth. Which I think in this judgment, and that's another criticism, that which was not gone into, some hyper technicalities were used, including blaming the victim. She's just a hapless girl. Blaming her that you did not raise this point during trial when she was not having good legal help then, or adequate legal help then. She doesn't even have a proportionate legal help even now. Ours is one small office. Best of the best lawyers are appearing. Best of the best lawyers appeared on behalf of central government and UP government to plead the Supreme Court that remove her security. So it is a disproportionate fight. So it was duty of the court to dig deeper to find out the truth. And that is the reason for the very existence of our courts, which I think to some extent the honorable bench did not do enough such hyper technicalities. And in fact, we had pointed out certain parallel sections which are in punishment, pari materia to the servant clause. Because why public servant is become relevant in this? Because there is a technicality on which there are judgments from both sides. Life imprisonment till end of the natural life of the convict, or life imprisonment simpliciter. Now judgments are, large number of judgments are there which clearly say that life means life. This is one hyper technicality which was used. Second technicality is that there is a judgment of Supreme Court which says that for this purpose, public servant in PCA case is public, MLA is a public servant, not in other cases. These are all hyper technicalities which could not have been gone into in principle at this stage of suspension of sentence.
Understood. One more aspect was. Please go ahead. Please.
We had pointed out section 5G, 5L, and 5P. We had pointed this out, but the reason which was given was that this poor girl did not point this out before the trial court, nor did the CBI. Now CBI is hand in glove, as I'm saying. So therefore, and the prime responsibility of the prosecution is the public prosecutor, that is the CBI's counsel, not CBI's counsel, but the public prosecutor. If they choose not to perform their duties properly, and the Supreme Court has taken suo motu cognizance to monitor this case, So what is expected of this poor child? I don't understand. And we were
Okay.
asking for further evidence. So that further
Okay.
evidence application has also not been decided.
Okay.
If further evidence was taken, the now when lawyers have changed, I am the lawyer. We could have brought in more evidence, which will
So,
reduce the
ca-
gravity of the mischief played by the IO of the CBI.
okay.
That
Ca-
was not
Can
allowed.
you please
Also,
explain for the audience, or say followers of the print, as to why is a MLA, who is an elected representative or who draws salary from the state exchequer, cannot be qualified as a public servant, even if we take the assessment of the court on face value?
if you want to hear my side, because in the Indian Penal Code, MLA is a public servant.
Okay.
I would say that. But again, I'm saying I want to give a long rope to the contents of the judgment. Therefore, I'm saying these are
Mm.
hypertechnicalities. In
Okay.
any case, he was a person in dominance which carries equal punishment. That is end of
Mm.
natural life. That
Right.
was rejected on the ground that you did not take it up during the trial. This poor girl, when she was having no legal help.
Yeah.
This is hyper-technicality. The court
So,
was duty bound to dig out the truth. The court was duty bound to give a chance to lead further evidence.
what is the road ahead, sir? Are you challenging the court order in
Yes,
the
we
Supreme
have.
Court?
Now, today, we are sitting in our office because we have filed caveat. We called the girl, also little girl,
Mm.
also to be very careful, because I got scared when the CBI, it was reported that CBI is going to file. So if CBI files and they, as an eyewash, engage a big lawyer and they again slant the argument in such a manner that Kuldeep Singh Sengar gets benefit. So we have filed caveat so that we can at least put up the real facts before the court, at least make an effort. Although the prime role would be of CBI and they would be heard more than us because they have the prime role. A
Mm.
complainant has always got a lesser role. It is always the state versus the convict or the
Yes.
accused, and the complainant has got very little role, or the victims have got very little role. But anyway, we have to put up this fight. But I'm really concerned if the CBI does not pursue this case very diligently.
Uh, there was there were questions about, say, security of the victim or her family. Then CRPF cover was given to her as well as her mother, and even currently, she has a CRPF cover. So, court was making that observation that just because she had fear on her life from Sengar, it could not have been, it could not have tilted uh, the judgment or the order towards her. What's your take on this? That just because she had a threat, the court thought that it would be amounting to saying that the paramilitary or the police will not be doing their job properly. What's your take on that? Was it belittling the victim? What's your take?
Well, future only Almighty can tell. What judges and lawyers are required to do is that they see the background of the case, collect facts which are available, and base their judgment on that. The fact remains that the family, with the greatest of efforts of central government and state government, the security of the family has been withdrawn.
Hmm.
This girl's children, two small little kids, rather toddlers, they have no security. Her husband has no security. So all this was in the notice of the honorable judges, honorable bench. So now I leave it to your viewers to take a call on this, to take their informed opinion about this, that is it a fair judgment or not. With CRP, with her family was attacked. With CRP protecting her, she was bombarded with social media attacks. Nothing. CBI has done nothing. Although they were duty bound too. Her husband was attacked just 2 weeks back. 2 weeks back. And the lawyer had mysteriously stopped appearing in this case, in this appeal only. Why? CBI's lawyer, who was trying to just do his job slightly well, honestly. So all these things were writ large, that a person who's getting so much support from CBI, he will not need to go and kill himself, the family members. So 5 kilometer range, I'm really surprised how that would be a safeguard. Because shooters will kill. No, the maximum guarantee to all shooters now is that if Kuldeep Singh Sengar Sahab doing all this, if he can get magnanimity and mercy of the court, they are only asked to commit a murder of a few of the family of the victim, minus, because there is no security with them. So this 5 kilometer, this thing I cannot really appreciate, because he is convicted in the other case of having the father killed, having got the father killed through police officers. Police officers. Such is the kind of influence this person is having.
Are you hopeful that the apex court will see through this, see through the order as well as the basis that formed this order giving relief?
I think it all depends on the way CBI puts its case. If they want to do an eyewash, we will be there to watch and guard that. If the entire thing depends on the CBI, but we will be there in the Supreme Court. We'll do our best. And this girl actually has got blind faith on Supreme Court even now, and that's a good sign. But we'll have to burn more midnight oil to live up to her expectations, which she has about of the Supreme Court.
Thank you so much for giving your valuable time to The Print, sir. That's all we have in this episode. Thank you for watching The Print.